Could you state your name for the record, please?
Erica Bedwell Michelle.
And could you state the name of your husband, please?
David Anthony Michelle.
And approximately when were you and he married?
August 20th, 1994.
Hold on one
And
second. He just entered the room. Hold on. I'm admitting him now.
ma'am, and when did you and your husband cease to live together as husband and wife?
I believe about January 11th, 2025.
Okay. And currently, well, when you filed for this divorce, where were you living at?
I was living in Dallas, Texas with the respondent.
Okay. And you're not expecting a child at this time? You're not pregnant?
No, sir.
Okay. And there's no reasonable expectation of reconciliation?
And no, sir.
And you're asking that the judge at the end of this grant your divorce?
Yes, sir.
In terms of the assets, in preparing for this, you developed a proposed division of assets and liabilities, correct?
Yes, sir.
And that is what's marked as Exhibit Wife 1?
I believe so, sir.
And that's what you're asking the judge to do today in terms of a property division, correct?
Yes, sir.
Okay. Now, regarding the vehicles, you're wanting both vehicles to be awarded to husband. You're eventually, this property split gives you the equity in one of the vehicles, correct?
Yes, sir.
And both the vehicles are located down here in Texas?
As far as I know, sir.
Okay. And do you feel that the property division that's contained in proposed division of assets is a fair and just property division as we know the estate?
Yes, sir.
And looking at the exhibit, you have some credit cards that were all charged off, correct?
Yes, sir.
Okay. Your American Express credit card was sitting at a balance of about $4,000, correct?
That's correct.
And you had a Discover Bank that was sitting at about $10,000, correct?
That's correct.
A Wells Fargo at about $9,200.
That's correct.
A Bank of America at $12,500.
Correct. Yes,
And the Barclays at approximately $8,500.
that's correct.
And you were able to show these through your credit report that's exhibit number 6, correct?
And that's correct.
You tried to get the last statements being charged off. Those last statements were not available to you and
That's
you were not
correct.
able to log.
Yes, sir.
And then your checking accounts, you only have 2 checking accounts. Well, a checking and a savings account at Bank of America, correct?
That's correct.
And the savings account has just under 6,000 approximately when we did this.
That's correct.
And the checking account approximately had about $100 in it.
That's correct.
And you have no other assets, no other bank accounts or anything else, correct?
That's correct.
Well, you did have one Robinhood brokerage, correct?
Oh, yes, sir.
Yeah, that's one we keep forgetting. And the balance of there is, what was the balance of that one?
It might be $25 or $50, maybe.
Okay. You haven't done any transactions. You just
Oh,
bought
no,
some
sir.
at one point.
No, sir.
And your inventory and appraisement is marked as Exhibit 2, correct?
Correct.
And you developed this on your own, and this is what you have as your inventory and appraisement, all the accounts in your name, correct?
Yes, sir.
And there were no children born during this marriage? There's no
Yes,
minors.
we have 2 children, but they're adult. No minors.
I'll pass the witness.
All right. Mr. Mr. Michelle, this is now your opportunity to ask Mrs. Michelle any questions that you may have based on the testimony that she just provided. You can choose not to ask her questions too.
I don't have any questions at this time.
Okay. Attorney Bagley?
Thank you. If I may call Mr. Michelle?
Sure.
Yeah.
Thank you, sir. Sir, at this time, you're in agreement that both the BMWs are in your possession, correct?
They are.
Okay. And the value of the 2008 is approximately $600?
Salvage is probably, no. I mean, it doesn't have any value.
Okay. You prepared an inventory and appraisement on this, correct? This
Yes.
case? Okay. And do you recall what you put down for the value of that one?
I can't remember what my attorney put down or what she asked me to put down.
Okay. You were included on the email to the court where I include the exhibits, correct, of wife one?
Probably,
Okay.
yes,
And currently you have a Bank of America checking account ending in 2578,
yes,
and you have a Nova Business Bank, correct?
yes.
Now, is Nova Business Bank associated with a business you own, or is that just how the bank was titled?
No, it's a business. It's my consulting business.
Okay, you have a what kind of consulting business is this?
I do online lending. So I work with private investors, Native American tribes to create online loan portfolios for them.
Is it an LLC?
Yes,
Okay, and it was created during marriage?
yes,
Does it have any other employees?
no.
Is it taxed as an S corp or just a regular?
It's a regular.
Okay. And you have a brokerage at Fidelity?
Yes,
Okay, approximately how much is in that brokerage?
none.
Okay. How much was in the brokerage at the time of this divorce was
I
filed?
think it was like 80,000.
And then at mediation, it was sitting at 101,000.
I don't remember, Mr. Bagley. Maybe. I mean, the market's gone down, so
Okay. So when was the last statement that showed a balance?
I believe it was December of 25.
Okay, and what was the balance in December 25?
I think it was at 95,000, maybe.
Okay. And you said as of today, that brokerage is now zero.
It has very little in it. Yeah.
Okay. Where did you transfer the money to then, sir?
It didn't get transferred. I used it as collateral to buy Bitcoin on margin, and I had a margin call.
Okay. And you didn't disclose any of the Bitcoin accounts, correct? In your INA?
No, at the time, no, I did not. So I don't have the Bitcoin anymore either.
Okay. And you haven't disclosed any of the statements and showing any of the transfers or anything else like that, correct?
Correct.
Okay. So as we sit here now in trial, you have nothing to show that you actually transferred this money. You have nothing to show that you bought the Bitcoin. You have no wallets that you provided for us or anything else like that, correct?
Correct.
Okay. You just are testifying to the court that you moved out.
Well, I wouldn't have moved it. It was removed. It was set up as collateral. Margin call was made. Bitcoin bought it at 90. It went down below 90. I got a margin call at 87. Couldn't come up with the difference. Lost the, you know, the amount.
When did you lose the amount? What month?
January, I think it was January 20th.
Okay. And when did you notify anybody that now this account has been
I
called?
have.
Okay. And do you have any other 401ks? You have one other 401k sitting at about how much?
Yeah, that money's gone too. Due to the fact that I was unemployed last year, I borrowed against it. So don't know. Well, you do know. You know, your client was attacking me online, impersonating me. Huh?
Sustain. Listen for the question, Mr. Michelle.
Okay.
Sir, at the time of your inventory and appraisement, you put down that was a balance of $16,758, correct?
Correct.
And you're now telling the court that that is now gone as well, correct?
I mean, there might be like 4,000 left in it, which cannot be removed. It's not vested.
Did you take a loan from the plan or just pull it out?
No, I pulled it out.
Okay, Your Honor, I pass the witness.
Okay. You may call your next witness.
Your Honor, at this time, I have no further witnesses.
Okay. Mr. Michelle, this is now your opportunity to tell the court what it is that you would like to do in order to resolve this case. Well, obviously you all are here for a divorce, so that's a given. But in terms of the property that is in existence, how would you
Yes,
like
Your
for
Honor.
it to be divided?
So, okay, sorry, Your Honor.
Go ahead. Go ahead.
So regarding the 401k with the money that was dispersed, may I? Okay. So I had to borrow, not borrowed against it. I withdrew it. You know, I didn't have any income coming in. Oh, sorry, hang on. I thought my internet was going out again. I had very little money coming in, as well, the court may not know, the petitioner was aggressively attacking me online, taking my videos and impersonating me. She and the person that she.
Your Honor, I'm going to object to
Oh,
testifying.
no. You don't get to object. That's
Hold on. I had to mute you, Mr. Michelle. You all do not go back and forth. Okay. He can make an objection. He has the right to make an objection based on whatever it is that your testimony is. It's up to me to determine whether or not I'm going to sustain his objection or overrule his objection. Okay. So you testify, he gets to object. Now, let me go back and review what the objection was. I don't even know if we caught the objection. Did you catch it, Joey?
I hadn't even made the objection yet, Your Honor. I just said objection.
Okay, so, all right, hold on. Mr. Michelle, you may unmute yourself and testify, and then we'll see what the objection is going to be, if any.
So the reason why I was taking the money out is I didn't have any income coming in. Part of it was due to the fact that the petitioner, by way of TikTok verifying it.
Objection, Your Honor.
Okay, what is your objection, counsel?
Testifying to documents and/or videos that have not been produced to us nor have been offered into evidence. Testifying to the
Sustained.
content.
I sustain the objection, Mr. Michelle. So that means as it relates to the videos and the content that you were speaking about, you can't speak about that.
So, Your Honor, that was provided to the petitioner before she got her counsel.
Counsel?
Your Honor, I'm still going to object. It's not offered into evidence.
Okay, yes, you do not have any exhibits. When we started, you said you were not tendering any exhibits for purposes of today's trial. If you want to speak about the TikTok content or income, you would have had to submit that in evidence today.
My prior counsel had submitted it to the court.
For today's trial?
No, not specifically for today's trial, but overall.
Right, so that's the reason he's making the objection.
Gotcha.
He's making the objection because it's not before the court today.
Okay, that's fine.
All right, you may proceed.
The petitioner has about $10,000 into account that she took from me. This was jewelry that was given to me by my parents as an inheritance. She didn't tell me she was going to sell it. She told me after the fact, months later, and said that she had used it to pay down her credit cards, which she did not. In fact, it was in the bank account. So that was money I probably could have used last year. I've got close to $80,000 worth of credit card debt.
Your Honor, I'm going to object to testifying about documents not in evidence.
Sustain.
Okay. Well, since I didn't return anything, there's nothing else for me to say.
Okay, do you have anything to say about what her testimony, the testimony that she provided?
Hang on, let me bring it back up. Sorry. I don't show the testimony. The documents I got were all of Bank of America, Robinhood, health insurance.
So she testified to the summary of requested relief, the proposed property division.
Oh,
She
that.
testified to that. She testified to the amount of money that she had in her Robinhood and some charge off accounts. Do you have any questions about any of that testimony?
Well, again, these credit card debts that she has, I had given her money, monthly allowance to pay these credit card debts down. So I'm taken aback that she has this debt. I mean, my question would be, where did the money go that I was giving her all that time?
All right, so ask it to her in the form of a question.
So, Miss Michelle or Miss Bedwell, what did you do with the money that was given to you over the months? $1,200 every month from 2021 to December of 2024, and from the time period of May of 2012 to May of 2020, when you were receiving $2,400 a month every month as an allowance. You
Yeah,
didn't.
I'm not sure if those amounts are correct or not, but I would say that any money I received, I used for expenses related to the kids and the household.
Your Honor, that is incorrect. I paid for
Okay,
all.
so hold on. She's on the, she's your witness right now, okay?
Okay.
So if you're going to ask her a question, you have to ask her a question and then get her off the witness stand and put yourself back on the witness stand.
That's fine. Okay. So, Ms. Bedwell, what household expenses were you paying from that 2,400?
I mean, there were various expenses. I don't have anything in front of me to refer to, but obviously groceries, gas, tuition, other expenses.
With regard to the amount that you received monthly, wouldn't that be part of your bank statement that would show that the deposits coming from my bank statement or from our joint bank statement?
Yes,
Okay, so you do know it was 2,400
I didn't say that it was not.
and over the time period. So if you multiply it out, it roughly comes out to about $280,000. So my question to you is, with the expenses that you claim that you paid, that doesn't cover the fact that 2,400 was spent every month. So where did the money go?
I believe I've answered.
Your Honor, no sense keep going down this path. We will be here all day if we do this.
Okay, so are you done asking her questions?
What happened to the painting that you took?
I have it.
Okay. And the $10,000, where is that?
What, $10,000?
The $10,000 you got from the jewelry that you sold.
The jewelry you accused me of stealing, been used to pay for expenses.
What, could you repeat that, please, Miss Michelle? It didn't come through. You were breaking
You
up.
broke up.
Oh, yes, Your Honor. I'm saying that the $10,000 that you were talking about from the jewelry that you claimed that I stole went to pay for expenses.
So you're saying you no longer have it?
I don't have all of it, no.
You're unbelievable.
Yeah, I'm gonna object to the
Okay.
sidebars. Ron.
So at this
Just
point,
saying.
Your Honor, there's no point in me asking her anything else. Like I said, we'll just be going round and round. She's not going to be honest about anything. So let's just move on.
Okay, is there anything else you would like for me to know?
Um, No, I guess nothing that would be relevant for this.
Okay. Right. Is there anything further?
If I say anything, counselor will bring it up as an objection, so no point.
Okay. All right, counsel, is there anything further?
Nothing further, Your Honor. Just closing.
Okay, you may proceed.
Thank you, Your Honor. Your Honor, as you can see from Wife's Exhibit 1, we had built a property division under the assumption that none of this money had actually been moved out. But according to the testimony now, at least $95,000 has been removed, plus $12,000 from a 401k has been apparently loaned out. We have been provided no documentation, notice of it, or anything, or we didn't even know about a Bitcoin account that he bought anything on margin. So we'd ask that there be a judgment against him for the amount in the division. Unfortunately, it doesn't appear there's any more assets that can be claimed by my client to replenish any of these brokerage account or any of the money owed. So we'd ask that we be awarded a judgment in the amount of $85,386 in regards to the brokerage account that was used on a margin. Thank you, Your Honor.
Thank you, counsel. All right, the court is going to grant the divorce between the parties on the grounds of insupportability. The court is going to also accept Wife's Exhibit 1 as a ruling of the court with the adjustment based on Mr. Michel's testimony to include a judgment in the amount of $85,386 in favor of Mrs. Michel over Mr. Michel.
Yeah.
Yes, sir.
I don't understand that. So that makes it sound like we had assets of 170,000.
Have you had an opportunity to review her spreadsheet?
No, I've been out.
Do you have it?
I'm looking at it right now. It's a 2-page spreadsheet.
Mm-hmm.
And
so this spreadsheet, according to what he just said, the testimony, when he did the spreadsheet, it was before you gave testimony today. And so the spreadsheet amount would be a lot higher if he had known about the testimony that you just gave. So the assets would be more in the 200, probably like 220,000 or so, if that were known at the time that this spreadsheet was created.
sorry, Your Honor, that doesn't make any sense.
So her spreadsheet, it has the total of 120, right?
Yes.
Okay. The 85,000, if you add the and maybe I missed, hold on, 120.
So are you saying that her debt, I'm now responsible for all of that debt?
227. Your testimony, do you remember what you testified to?
You mean today?
Yes.
Yes, ma'am.
Didn't you testify to a Bitcoin?
I had, yeah, but I don't have the Bitcoin. The Bitcoin's gone.
Right. That's an asset.
Correct.
Correct. That's an asset that you didn't split with her.
But that wouldn't be the whole amount she would get. She would get half of that. That's the part I'm not understanding. The 85 makes it sound like we had assets well, approaching 200,000, which we did not. We had more in the line of 100,000 all in, which is no longer around.
If I may, Your Honor.
Yes, please, because I'm going back to look at exactly what he said. Go ahead.
Thank you, Your Honor. Had we known about the Bitcoin being on margin at the time, we would have added in the value of the Bitcoin into this and subtract out any of the margin payments in there. So what I have on my spreadsheet is the entire property the parties owned as we knew it in mediation. Then we take into account my client's debt of 44,741. So the proposed split where we're awarding her basically just her checking accounts and part of the brokerage account gets us, if we look to page 2, into a what amounts to a 51-49 split, or that just rounded up. So it's about close as I can get to a 50-50 split, taking into account the assets that were known. Now, again, the Bitcoin was not known, so I don't even know what the value was. It could have been drastically higher. But here we are. So I took in the debt, and that's how I got to the split of as close to 50-50 as the numbers would go on that one.
Did you have any questions on that one, Mr. Michelle?
I'm still unsure on how they arrived at 85,000 to the petitioner.
Then you testified about your 401k. So you understand the 401k part?
Yeah, I get that, Your Honor, but it looks like she's saying that she should get 90% of that.
90% of the 401k?
I'm looking at the column where it says amount to petitioner, and she has 85,000 of that Fidelity brokerage account and 16,000 to me. I don't understand that math.
You're on page.
I'm on the first page of the proposed division of assets and liability spreadsheet. Is that what
Yes, I'm looking at it. So tell me exactly where you're looking.
I am looking under the brokerage and mutual fund accounts. Husband's account at Fidelity Brokerage shows $101,650. Column amount to petitioner header shows 85,386 to the petitioner and 16,264 to the respondent, me. I don't understand that math. Why she would get 85,000 of that account.
If I may.
Yes.
Thank you, Your Honor. We got to that amount when we factor in the amount of debt that she is going to be responsible for as well, and we're trying to do an overall split. An overall split includes the assets and debts of the estate, and that is why the award up there of the brokerage account is in that amount, because it offsets the amount of debt that she'll be taking. As for the 401k, we're awarding the 401k of the amount that we knew of, 16,758. That's at the bottom of the page, 100% to respondent. So respondent is keeping both the cars, the accounts in his name, checking accounts, the 401k in his name. The brokerage is where we're making up the debt that exists as the estate as we know it. And that is how we get to the 85,000 to get to the total all split. It shows on page 2 the percentage net and the split net of how much everybody gets. The net of the community that the parties are keeping is 46 to petitioner and some odd, and 45 to husband and some odd. So that's how we get to the split. So I agree, there's not $200,000 here. We're looking at the actual split, and it's showing the entire estate is made up about for about $100,000 the entire estate. And that's how we're getting to the split due to the debt that's also included.
So can you see that on the second page where it says the net? So it has the 44 in parentheses, that's the debt. So you have to subtract that from the 90 that you're looking at. That's why the split is so close. It's 51% to her, 41% to you. And spreadsheets can be confusing. Sometimes they're even confusing.
Right. But you were going to award her 85,000.
Okay. He just explained that very thoroughly. Now, I don't know how to explain it any differently than what he explained. I followed after your testimony and he explained it. So I don't know how to explain it any differently.
Right. He's taking the bulk of it and saying, well, she's got 44,000 of debt. I did not submit any paperwork to show that I have $80,000 of credit card debt. So I get that. But Mr. Bagley's saying the way that they did the accounting, that she should get nearly 90% of the 401k if it was there as compensation to offset her credit card debt.
That's not what I got out of that. Again, like, you know, I don't know how to explain it any differently.
Sorry, Your Honor. I apologize for trying to step on you.
No, it's okay. Like I said, spreadsheets can be very confusing even for the court at times, but when you take into account the spreadsheet plus what your testimony was and how he explained how they got to that, including the debt, that's how it gets to that 51% versus 51% to a 49% breakdown.
Okay.
But you're explaining it would be something totally different. It would look more like a 90-10 split. That's not what happened here.
Okay.
So look at that second page, you look at the 90,000, you have to subtract the 44,000 that she has in debt.
So, okay. So just to make sure I understand, so today, when you say you're ruling for 85,000, you're not, that's not how much she's entitled to. They're proposing that she's entitled to 47,000.
No. No.
Okay, good.
Mr. Bagley explained that better than I could. Mr. Bagley, would you explain that, please, again?
Thank you, Your Honor. From the accounts, looking at the assets liabilities, so we're taking the total assets of 120,000 and some odd, subtracting by the total known debt of 44 and some odd, and the retirement account of 16,758. That brings the total estate to about $110,000. From that, we're subtracting out the debt of $44,000, and we're then taking the split of approximately 51-49%. That's, in doing so, we have to take that money from somewhere to offset the debt in there. We're taking the money from the, well, was existing, the Fidelity brokerage account to offset that 44K in debt to get us to basically a 50-50 split of the marital estate. When we say marital estate, what that means is we're taking the total assets and the total liabilities, and that number you come at the bottom, that is your total estate. To get to a 50-50 split, we have to shift money over to offset the debt. So that's where it comes with.
Okay, Your Honor, I don't know if this is possible, but is there any chance I could get a continuance to submit my amount?
We just concluded. I made a ruling.
Okay, okay. Then I don't have the money, so I don't know what to tell you. I do not have $85,000 to send her.
Okay, counsel, how long
Yes,
will
sir.
you need to prepare the order?
I could have this ready in 14 days, Your Honor.
Okay, let me give you a date. And Mr. Michelle, if you have any questions further, you can ask Mr. Bagley. I can only clarify as much as what I can see. If you have any questions in addition to that on his spreadsheet, you can ask him. Well, not today, or not right now. You can ask him offline.
Okay. And Your Honor, for purposes of scheduling, are your entry dates by Zoom also?
Yes, they are by Zoom, and Judge Lee has my entry docket.
Oh, perfect. Then I can take whatever dates available on the court then.
Friday, May 29th, 2026 at 9:30.
Thank you, Your Honor.
And Mr. Michelle, the way that works is that's an entry docket. So if after Mr. Bagley, Attorney Bagley prepares the order, he's going to send it to you for you to review. If you have any objections, you will appear at that dismissal hearing and make your objections at that time. Now, I want to be clear on objections. if his order is in compliance with what my ruling is, then the court can still, and when I say the court, my associate judge, Judge Lee, she
Mhm.
can still enter the order. You understand?
Mhm.
As long as it's in compliance with what my ruling was. Now,
Correct.
if you have any objection in terms of the form, something that I made a ruling on that's not included, then you definitely want to make your objections to that.
Okay.
And I would recommend that you do your objections in writing, just so there can be a record of it, okay?
Okay.
All right. If there's nothing further, you all are dismissed. Ma'am, you hold on one
I do not
second.
understand the word reference, ma'am.
Oh, hold on 1 second. Let me mute you. Okay. You do not get to pick and choose what you want to understand and what you don't want to understand. You have been making objections this entire time. So to some degree, you do understand what is going on. I'm not going to allow you to proceed and pretend that you do not know what is going on here. You just made an objection almost to every single question that was asked by his attorney of him. So you either answered the questions truthfully, which you raised your right hand and swore to do, or you just answer no. But to say I do not understand, I'm not going to allow you to do that, because you do understand to some degree what is going on. You also defaulted him. This is your default order. So you do understand to some degree what is going on. You do not get to pick and choose what you want to participate in. Is that clear? And you can nod your head, because I'm keeping you on mute until I remove you off of mute.
In this deeply shocking and emotionally charged hearing, a defendant named Antoine Williams appears before Judge Simpson, having been brutally attacked inside the county jail by 3 other inmates who jumped him in his cell, leaving him with serious injuries, including a fractured jaw that required surgery and has been wired shut for weeks. Antoine's attorney makes a compelling argument for immediate bond reduction, explaining that her client came into custody as a healthy young man and is now leaving in a medically compromised state through no fault of his own, that the jail has demonstrated it cannot keep him safe, and that continuing to hold him puts him at serious ongoing risk of further violence. The prosecution pushes back, arguing that the attack has no bearing on the legal reasons he was held in the first place, and that his underlying charges, including home invasion and assault, are still extremely serious regardless of what happened to him inside. Judge Simpson listens to both sides carefully, but it is clear from his questions that he is genuinely troubled by the situation, asking detailed questions about the attack, Antoine's current medical condition, and what the jail is doing to ensure his safety going forward. In a ruling that clearly reflects the judge's genuine human concern, Judge Simpson reduces Antoine's bond significantly, telling both sides plainly that while the attack does not change the legal charges against him, the court cannot in good conscience ignore the fact that a person in its custody was seriously injured while the state was responsible for his safety. Closing with a powerful reminder that the presumption of innocence means the state has an obligation to return defendants to court in the same condition they arrived.